Thanks, Art. Good to see you as the now Vice President. As you mentioned, I was Vice President of Tarwirri over 10 years ago. And I first attended the legal conference in 2008, some time ago, up in Brisbane. It's good to be back. Nyanawa kupanyan waranjari Wurrung miring nyarok mene nyochong kolonalamin mene nyochong bonjo pawa mene nyochong kolamiring. I acknowledge that we're sitting on Wurrung country and pay deep respect to their elders, ancestors and ancestral creation beings, and the Wurrung people's continued connection to country and culture. My name's Jidah. I'm a Djab Wurrung man. I grew up on the Framlingham Aboriginal settlement in Western Victoria, and I'm now the chair of the Victorian Treaty Authority. I want to speak a little bit about my history at Framlingham. As a young Aboriginal man immersed in the lifestyle and culture of my community, it was a privilege to learn from my old people and elders about Aboriginal ways of knowing, being and doing. One thing that fascinated me growing up was that learning about the history of my community and the operation of oppressive Western laws that subjugated our people, and that really incensed me. And despite the operation of laws such as the Aboriginal Protection Acts, often what I've come to learn is that the intent of those acts did not achieve the outcomes desired. Many will recall those acts restricting our civil liberties, such as who you could marry, where you could be, where you could work, and plenty of other matters. Our people resisted those laws, and Aboriginal ways of knowing, being and doing, and the remnants of our systems of law continue to operate and persist despite the effect of those pieces of legislation. While it impacted our ability to practice our law as Aboriginal people, those acts didn't quash the operation of our law systems. Particularly, I want to talk a bit about kinship law. Our people related to each other and cared for each other, as we always have. I just want to quickly note, on the weekend, the unveiling of Uncle Archie Roach and his wife Ruby Hunter's statue down on Gertrude Street. Those protectionist acts caused Uncle Archie to be removed from Framlingham, and in his later years, his kin, people from Framlingham recognised him and brought him back to country and welcomed him with open arms, and he learnt from his old people his ways and became a deeply cultural man and touched many hearts across the nation. So where Western law took him away, Aboriginal law brought him back in. And to discuss another example, down at Framlingham, up until the 1970s, the government administered the Framlingham settlement, or the reserve. In 1971, the Aboriginal Lands Act imposed a Western governance structure on our community in the form of a sui generis trust structure. Despite the operation of that legislation, it was quite devoid from how our community operated on the ground, with elders and heads of family sitting there as decision makers and guiding our community. Their cultural authority was very salient in the operation of our community's affairs. Now, having become a lawyer in the Western sense, I've got a little understanding of the Western legal system. What I've learned is that Aboriginal law persists and exists despite colonial forces rejecting its operation. For our mob in Victoria, Aboriginal legal systems are alive. They're not always intact or explicitly in use, but the treaty process presents to us an opportunity to make the implicit Aboriginal law explicit. If we take law and look at it semantically, law stands as a linguistic gateway to describe our structures, principles, and actions that give meaning to Indigenous worldviews. And these worldviews, as they map out across our country, across our songlines, our ancestrally created territories, and throughout our kinship systems. And you witnessed a bit of that earlier with that really deadly performance from Jidah. Our law is embedded in country. It's the knowledge that's expressed through story, song and ceremony. It dictates the rules of land and sea ownership, our ancestral origins, our obligations and our responsibilities to each other. Our law is practical and it's harmonious, setting the rhythm of life. And treaty making can be seen as a recognition space for Aboriginal law. As sovereign peoples, treaties serve also to recognise the Western system, the legal system and their government. It's a space where the two systems can speak and relate on just terms. So, talking a bit about the Treaty Authority, we're an independent and impartial body tasked with facilitating the formation of treaties between the State of Victoria and First Peoples. We're also tasked with providing for the resolution of disputes that come up along the way. Our work's grounded in Aboriginal law and cultural authority. It's led collectively by a panel of 5 members, of which I'm one. We have another one of our members here with us today, Duane White. We're committed to Aboriginal self-determination and empowerment. An important feature of the Treaty Authority's creation is that we're established by agreement between the state and the First Peoples Assembly. Legislation was later passed that provides our legal personality and powers, but it's important to remember that this legislation is facilitative of that agreement. It's not enabling the creation of this body. It's a novel legal entity that's independent from the state. It sits in a unique position at the intersection between Aboriginal and Western legal systems. The Treaty Authority administers the treaty negotiation framework, which is the rule book for the treaty process, under which treaties will be negotiated. And being grounded in culture and having active engagement with Aboriginal law is an important expression of the distinct cultural rights we have as Aboriginal people under the Victorian Charter, and also reflects the various rights of Indigenous peoples under the UN Declaration on the Rights of Indigenous Peoples, including the right to self-determination, the right to maintain our political, legal and cultural institutions, and the right to practice our cultural traditions and customs. In performing our role, the Treaty Authority has a duty to uphold, observe and embed Aboriginal law across our work and across the treaty process. It's mandated by the Treaty Authority Agreement and also the negotiation framework. To understand what this duty entails, the Treaty Authority has to engage with the meaning of those terms: Aboriginal law, 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 LORE, and cultural authority. The terms are described in the framework and the agreement, but not quite defined. And those documents mention that Aboriginal law forms an ongoing legal system on equal footing with the Western legal system. It stems from country and is intertwined with culture and the First Peoples' way of life. It's relevant to agreement making, decision making and governance structures. It's embedded within the dreaming, art, song, ceremony and dance and stories of First Peoples. The meaning of Aboriginal law varies between First Peoples communities, and each community must self-determine how it's defined for them. Turning to that term, cultural authority, it's about who has authority to speak for country and on behalf of people. It's held with humility and respect and carries a responsibility to country and community. It's relational, intergenerational, It's matriarchal and patriarchal. I want to spend a bit more time talking about this idea and concept of Aboriginal law, which is First Peoples systems that prescribe Indigenous knowledge and behaviours in relation to each other and to our country. It's the basis for our governance, our spirituality, and also how we manage and look after the land. It's applicable to our communities and it helps solve everyday problems. The refusal by colonial authorities to recognise our law is a hangover from the legal fiction of terra nullius, the idea that there were no people, no governance, and that the land was lawless before British invasion. We weren't considered to possess an ordered and sophisticated means of decision-making or of social control or of moral and ethical codes of behaviour. We know that's not true. The reality is that we have legal plurality in this country. Whether it's recognised or not, it exists. From the Aboriginal perspective, Western law is somewhat lawless, increasingly devoid of its own stories and morals. And at the Treaty Authority, we're finding it helpful to frame the distinction between LAW and LORE, noting these terms are used interchangeably, but there's been a tendency throughout history to consider Aboriginal law as subordinate to Western law, which I think explains sometimes why LORE is being used. But given those terms, LAW and LORE are in our foundational documents, the Treaty Authority is considering LORE to be about the stories that we hold, the source of our morality and guidance on our behaviours, which directly relates to country, the stories that are embedded in country and our songlines, in our oral histories and in creation. It might be helpful to frame Aboriginal LAW as the rules, the positive law that flows from the story, or the law posited by agreed upon authorities, such as our elders. It includes things like kinship relationships and conventions. In the Western tradition, legal positivists say that laws are or should be separate from morality. That tradition says that natural and positivist law are separate independent spheres. For others in the Western tradition, natural law is the source of ethics or morality from which positive law should comply. Aboriginal law doesn't engage with those differences. The source of our law is the land itself. And one difference between the two systems is that Aboriginal law is relational. Western law tends to be transactional. An example being the primary form of redress in civil cases is monetary. In the Aboriginal world, it's about fostering harmonious relationships. I note the work of Dr. Arnie Mary Graham, scholar and Kumbamari and Waka Waka woman. She refers to this term relationalism as a key concept in our worldview. Arnie Mary says that relationalism is laterally expressed. It's not hierarchical and draws into view relationships with country, people, and our non-human kin. Arnie Mary uses the term autonomous regard, that is, autonomy with regard to the relationship to others. Autonomous regard suggests that any attempt to deny or bypass the other is impractical and unhelpful. We can attend to, regard and behold and weigh each other while still retaining autonomy and dignity. Relationalism is not only to keep relations flowing when relations are good, but also when relations are tense or difficult. For First Peoples and the state to be in right relationship, we need to be in a lawful relationship. And treaty presents an opportunity to create a lawful relationship. It's a mutual recognition process, one that can recast the relationship between our peoples and the government. It's about giving power to and not power over, which is about win-win diplomacy. I want to talk a bit about law and cultural authority in the treaty process. It requires active engagement of cultural protocols and values. Under Aboriginal law, we have a responsibility to learn, respect and understand the law and our ways of knowing, being and doing. Aboriginal jurisprudence is about strengthening relationships. And treaty is an invitation for Western law to work on itself, to understand itself, for lawyers to sink themselves into their own tradition. And through understanding the Western system, we'll be able to better come to a relationship with the Aboriginal system. Western law isn't in the tradition of this land. Western lawyers being able to understand that Aboriginal jurisprudence is about strengthening relationships, whereas in the Western tradition, lawyers are often taught to be adversarial. I talked about relationality. Treaty isn't something that should just be transactional. Many of you know that Western lawyers will tend to conduct negotiations in a transactional way. It could be said that in negotiations, Western lawyers are trying to remove law from the negotiation table. In the negotiation space in treaty, we're bringing Aboriginal law in and bringing it to the table. There's benefit to doing that and bringing it into the negotiation space. So over the course of the last 12 months, at the Treaty Authority, we're building the foundations to understand what we can do to uphold and observe Aboriginal law. And one way is by creating those spaces to practice Aboriginal law. And I'll talk a bit about a couple of activities, key activities where we proactively uphold law, and that's in the areas of delegation forming and dispute resolution. Delegation forming is a process required in order to commence treaty negotiations at the local traditional owner level, as opposed to the statewide process. Before the negotiations can begin, all traditional owner groups that have interests over the same country must form what's called a delegation. There can only be one delegation over a particular territory. A delegation is a flexible and inclusive and unified mechanism to enable the TO groups to collectively negotiate over a defined territory. Relevant groups must reach collective agreement about certain matters in order to form their delegation. Those matters might include leadership arrangements, subject matters to be negotiated, governance and decision-making arrangements, and how their membership is kept informed. Once formed, that delegation is ready to sit at the negotiation table with the state. While the negotiation framework sets out what must be agreed, it's largely silent as to how that agreement occurs. And the process itself at its heart is a self-determined one. The Treaty Authority has a two-step process to support delegation formation, which I'll mention briefly, that we will be out gathering information from traditional owner groups about their vision, goals and expectations for agreement making, and any aspects of Aboriginal law or cultural authority that the group wishes to uphold. We'll seek to bring the groups together in a culturally safe, respectful and non-judgmental way, in a way that brings Aboriginal law into the space. And yarning circles are an important cultural tool that can be used to bring groups together in this way. With the consent of the groups, we may also invite elders into the space We may engage external facilitators or experts to provide advice about specific issues. I want to just briefly touch on some of the principles that will help embed Aboriginal law in the process. 1, embedding deep and active listening. 2, grounding agreement making in ceremony, ritual and cultural protocols. 3, ensuring genuine willingness to participate from all groups. 4, supporting self-determination through processes that are flexible and designed with participants. 5, processes will be developed in a way that recognises power imbalances and the potential for future abuses of power. 6, there'll be a focus on culturally strong outcomes where participants benefit, acknowledging the interconnectedness of traditional owner groups and the need for sustainable agreement making. Lastly, the process will seek to heal, to develop trust and enduring, respectful relationships. So beyond these principles, I'll also touch on, if I could move to the next slide, what we're calling a dilly bag of tools and protocols that we've developed to enhance agreement making and dispute resolution processes. Some of those tools, don't know what I did there. If I could get some assistance, move to the second slide, please. Some of these tools include using culture, place, ceremony and song, dance, and also coming around with food to bring our participants together in a way that celebrates the unique strengths of our traditional owners and encourages the sharing of wisdom and story. I do have another slide. Would be great to get to if I keep mucking it up. Just to get back to the tools I was mentioning. Practicing inclusion and encouraging non-adversarial win-win approaches. Opening yarns to think about, dream of and visualise what living in cultural abundance might look like. And focusing on mending, building and sustaining relationships and trust between participants. So the Treaty Authority also intends to iteratively build upon strong cultural practices. This means learning from our mobs, adopting their practices and processes where appropriate, and learning as treaties are negotiated and parties come to the table. By centring Aboriginal law and cultural authority with a focus on Aboriginal peace-building principles, processes like delegation forming and dispute resolution will be culturally strong and empower groups to reach sustainable agreements. So to wrap up, I want to reiterate that concept of legal plurality in this country, whether it's recognised or not, that it exists. A treaty law is novel for Australia and for Victoria, and the opportunity before us is incredibly exciting. It's an exciting meeting place where the two systems of law can speak to create stronger relationships. To all the Aboriginal and Torres Strait Islander lawyers in the room, I encourage you to get involved, to seek to be a part of and understand this process. We need people who can understand and respect both sides, who can be fluent in both ways of the law. You have the gift of walking in two worlds. Aboriginal law exists through continual practice and regeneration. It's active and not static. Remember that engaging in cultural practices is how our law is practiced, learned, relearned and transmitted. To non-Aboriginal lawyers in the room, I invite you to enter into a dialogue with Aboriginal law. One good way to start is by engaging more deeply with your own legal tradition, to give more depth, understanding and reasoning of why that law exists. Western lawyers having a deeper relationship with your own law will help it become more adequate and more mature. Bring an open mind and an open heart when entering the treaty space. One that respects Aboriginal law, one that doesn't take an adversarial approach to treaty making. Be open to respecting Aboriginal spaces. And on a final note, I want to throw in a plug that we're currently recruiting a senior lawyer at the Treaty Authority, which is an incredible position. We're also recruiting for a cultural council, and that position is being instated as a position equal to our general counsel, our Western lawyer, bringing a cultural person into this position to assist the Treaty Authority and its members to uphold Aboriginal ways of knowing, being and doing in the organisation and in the treaty process, and working with traditional owner groups to help articulate their law and bring it into the treaty process. So I expect some strong applications after this conference and look forward to meeting some of you during the course of the day. Thank you.
So thanks very much, Jidah. That was amazing insight into the work of the Treaty Authority. And there's a couple of points that I wanted to pick up on the back of that. I think it's really amazing to really highlight the fact that Aboriginal law and sovereignty exists and persists outside of the Western legal system, and the work that the Treaty Authority is doing is really groundbreaking in the idea of really bringing out effective legal pluralism and having a recognition between both systems. So we've got time for a couple of questions. If anybody has any, please put up your hand. I'll give you a couple of moments, otherwise I've got one for you. All right, I'll kick things off. So you mentioned the fact that the Treaty Authority is a novel legal entity. I was wondering if you could speak to the significance of that for the Treaty Authority and how that sort of came about.
Thanks, Art. As I briefly touched on, there's the creation of the Treaty Authority was born from an agreement signed between the State of Victoria, the Minister, and the First Peoples Assembly, the chairs there, and there's no other legal entity in this country that's been established in this way. The legislation that brings life in the Western sense to this body was passed in 2022 and gives a unique status to the entity. It's not quite a statutory authority that reports to a minister in a traditional sense, but is completely independent from the oversight of the state. That the body is accountable to, yes, the people of Victoria and the community at large, but also accountable to the people, or Aboriginal people in this state. It means that we're still bound by elements of Western law and regulatory frameworks, but we have an additional layer of accountability to our own people. It's a really exciting place to be in, and we're deeply honoured and committed to making this a body that incorporates Aboriginal governance in really strong ways, that can be a beacon, hopefully, of new ways of doing things, improved ways of operating, and hopefully serve as an inspiration for other bodies like this in the future.
Thanks, Jidah. Any other questions? We've got two in the middle here.
I'll go first. Given that our law, our LORE, is often gendered, is there a mechanism within the treaty to protect our sacred women and men's business?
Good question, thank you. So within the membership, we do have mixed genders. We've been spending a lot of time grappling with the concept of Indigenous data sovereignty and the need to protect sacred business and knowledge in the process. There's mandated obligations to uphold data sovereignty, which is about controlling the access to Indigenous data and Indigenous knowledge. So there are mechanisms we've created, and there's a protocol available on our website you're welcome to have a look at that talks a little bit how we'll be handling information from traditional owners. And we'll be learning along the way as we engage with our traditional owner groups on best practice and ways to ensure that that knowledge is protected. I'll just also plug our website. It's treatyauthority.au.
Another question
Yeah.
over here.
Jidah, you said Western law is not in the tradition of this land. Can you just expand on that? I'd love you to talk about that.
Law has been operating in this country since time immemorial. Our systems of, as I mentioned, governance, our rules of behaviour, our social structures, all encompass our systems of law, the ways we relate to the country and to each other. And the source of that law comes from the land, embedded in our in creation and in our stories. And the Western system has been imported here for less than 200 years, and it's important for that system to have a sense of humility and understanding, to not consider to always be dominant over a system that already exists. And talking again around mutual recognition is about having those two systems being able to speak and translate across, which, as I mentioned, treaty is an incredible opportunity for that to occur.